I was asked in the comments if I could talk about bail, and yes I can. So we need to consider two main things. That's pre-charge bail and post-charge bail. So let's start at the beginning. The police arrest you for something and they take you to the police station to be interviewed. There's something called the custody time limit. The police can only actually keep you in the police station for up to 24 hours, although that can be extended with the permission of the magistrate's court, but the maximum is 72 hours. After that time, they have to make a decision. They either have to charge you or they have to release you. But what if they haven't finished their investigation? What if they're not quite sure? Well, then there are three options. Oh, sorry, I'm going to get distracted because there are dogs. Hello, hello, hello. Sorry, it is part of the brand, honestly. If I see an animal, forget, continuity. Where were we? Oh, yeah. So they've got three options. They can RUIU, release under investigation. They can release you on unconditional bail, or they can release you on conditional bail. So what's the difference? Released under investigation is just go away. We may be in touch. So there's no return date, there's no conditions or anything like that. You're just free to go about your business. However, there may come a time when they say, come back in, we need to charge you. Unconditional bail, they actually give you a date to return. But other than that, you're free to go about your business. So what's the difference between RUR and unconditional bail? It's basically that there is a return date. If you don't attend on the date that you are bailed to, you actually commit a Bail Act offence, whereas under RUI, if they say come back in, you can say, you don't have to do anything, they'd have to come out and arrest you. But what about conditional bail? Well, they can impose certain conditions. That could be residence at a particular address, it could be to stay away from a particular location, it could be to stay away from a particular people. What they can't do is they can't insist you live at a bail hostel. They also can't make it a condition that you return to be interviewed. But other than that, they can pretty much impose whatever conditions they like. I mean, they can even do curfews and things. There is a time limit though. Unlike RUI, which is they can just keep you hanging around for years if necessary, they can only initially bail you for 3 months, although that can later be extended up to 9 months by the police, and indeed 12 months if they get the permission of the court. But you can never be on bail for more than 12 months. Although at the end of that, they can just say, okay, well, we'll just RUI you then. So you still have all this hanging over you. For some organisations, because this doesn't just apply to the police. So say, for instance, the Serious Crimes Agency, let's risk going this way today. The Serious Crimes Agency, the Financial Conduct Authority, Customs and Excise, they can actually bail you for up to 6 months, although then after that all the same provisos apply, so the 9 months and then the 12 months limit. So that's pre-charge bail. Now, one interesting thing is they can actually remand you in custody, of course. That is another option. If they decide that bail's not appropriate, then they just remand you in custody. It's actually the custody sergeant who signs off on that. But then you must be, charged and produced at a magistrate's court at the earliest possible time, which is, if it's Monday to Friday, because like the courts sit on Saturdays, then it's the next day. Sometimes it's even the same day if they're quick enough. If you're nicked on a Saturday night, then you're going to have to wait until Monday. But then what if you are charged? Then it becomes a matter for the court. So let's say you are remanded, the police basically hold you in the cells. They say, we're keeping you in custody, and they produce you immediately. In that particular case, on your first occasion at the court, you can apply for bail. Now, once you get to court, there's actually a presumption of bail. Interestingly, with police bail, there used to be a presumption against bail. Now it is neutral. They just have to consider whether they think bail is necessary. But what are the grounds for refusing bail? Well, the CPS, the prosecution, or whoever the prosecutor is, has to show substantial grounds for believing that you will either fail to attend, commit further offences, or interfere with witnesses, or otherwise the course of justice. It used to be that you could also be remanded for your own protection. Now, interestingly, that has been removed in relation to court bail, but it still exists in relation to police bail. That could be because they think you're at risk of self-harming, or it can be it's particularly high-profile, notorious case, and they're just worried that if they release you outside, then the mob's going to lynch you. Let's go this way, slightly safer. So, they have to show substantial grounds. They can't just, say on a whim, sort of, oh, please lock this person up. They would have to argue and say, this is why we say it. Although it can be just something like, this person's looking at a really lengthy sentence and the evidence is really overwhelming, so they've got every incentive to do a runner. Or, there's only one witness in this case, say it's a DV, and there's already a history of abuse and coercion. Therefore, we think that he might try and nobble the witness. Or it could be like your Just Stop Oil people, where they make it very clear that they will just carry on offending. So that's the commit further offences. You can obviously challenge that, and you can say, no, I think, this is all rubbish. And this is an exercise we do a lot when I do the advocacy training. We do a lot of this with the young junior barristers as part of their narrative advocacy. It's like, here, do a bail application. Tell us a sob story as to why this person shouldn't be locked up. Ooh, just switch hands there. Just go down yet another precarious scree slope. Honestly, it's worth it for the views I'm taking you to. So you can say either should be released on unconditional bail. More often you say, okay, well, we think conditional bail can deal with this. So if it's interference with witnesses, it's like not to go with a certain area, not to contact somebody. If it's you're worried about commit further offences, or absconding, it can be something like live at an address. They can do what's called doorstep curfews, where the police can randomly knock on your door and say, come to the front door, and shows you still exist here. And if you don't, you actually commit an offence. They can put you on tags, all that sort of thing. So yeah, you can argue sort of all these points. Now, theoretically, every time you are produced at court, if you are remanded in custody, the court must consider whether to grant you bail. However, obviously, if they banged you at once, they tend not to do that. You can also apply to the Crown Court. So say you don't get bail at the Magistrates Court and you get produced at the Crown Court, you can say, well, they knocked me back, but how about you, Judge? How about you letting me go? But once you've had your sort of 2 attempts, that's it. You can't make another attempt unless there is a material change in circumstances. So you'd have to show, it could be something like, well, this witness has now made a retraction statement, although, especially in DV cases, they're always very suspicious about that. But it could be, I've now put forward my fantastic alibi, or there's been there's been a change in the law. So what you are now accusing me about, I have a defence, or it's no longer offence. Things like that. Anything else I need to cover? Because I'm sure bail's quite a complicated subject. Like I say, I don't actually rehearse these. I just like to ramble them. So while I'm trying to think of things, I'll just show you around this rather nice spot, because I know you all like an engine house. As I said, there is a presumption of bail, but there are certain offences where that presumption vanishes. So say, for instance, you're up for murder, then there's no general presumption of bail. And for certain offences, certain serious offences, like murder, if you have at any stage been convicted previously of such an offence, then you can only be granted bail if there are exceptional circumstances. So it's like you get one free M word, but then after that, no, that's it. No more bail for you. If you are remanded in custody, by the way, there's something called custody time limits. Theoretically, they can only keep you in custody for up to 112 days. Although that can be extended, and a lot of the time in serious cases where you appreciate it's going to be a sort of long procedure, and your guy's probably just clocking up time on remand anyway, then they're not often that opposed. My first ever appearance on my feet was a murder case at the Old Bailey, because our head of chambers, who was doing the case, leading my pupil master, neither of them could be bothered to actually go along for a custody time limits hearing, you know, an unopposed one. Now I, of course, was very nervous. It's like, it's my first day ever in court and you want me to go and do a murder? And as our head of chambers pointed out, he said, well, what's the worst thing you do? You mess it up and they release him. So yeah, I suppose he did have a point there. Anything else we need to consider? Done bail, done what you get released. If you are remanded in custody, by the way, and you are subsequently convicted, then the time you spend in custody counts towards your sentence. So that gets knocked off. But interestingly, time spent on a curfew, if it's a long enough curfew, like more than 8 hours a day, because quite often they'll curfew you so that you can, during the day, still go to school or go to your job, but you have to stay in at night, just so you know you can't go out robbing. So a lot of the time it is actually worth getting put on a curfew, because you may as well like clock the time up. Sorry, just giving you another little view there. So I've done curfews, done all that, bail, done presumptions of bail. Yeah, to be honest, I think that's pretty much it. Some people have said, you know, about why are people not getting bail you know, with all the riots and things like that. And like I say, police bail is, I've explained why they, you know, if they're sort of thinking you might be committing further offences, and court bail, it's very much the same thing. One thing the CPS are supposed to take into account is if there's no realistic prospect of a custodial sentence at the end of this, even if they don't think so, you know, even if the normal objections to bail, you know, could be proved, there were substantial grounds. The argument then is, well, you can't just lock somebody up just because you think they won't turn up to the trial when they're probably actually not looking at a non-custodial. You know, basically bail them. If they don't turn up, they commit a further offence, and we can add a bit of time on at the end for that. I mean, that is very common. One thing, if you're ever done for a bail offence, normally when you get sentences and you get done for loads of offences, a lot of the time they'll just sentence you concurrently. In other words, you get loads of sentences, but you serve them all at the same time. However, with Bail Act offences, you serve those consecutively. So it's like, congratulations, you're banged up for X for the original crime, and also you're getting another 3 months for failing to attend. Also, I suppose I can also chat about the Assange thing, because one thing you can actually do with bail is you can put up securities and sureties. A security is where you yourself post a sum of money and say, if I don't turn up, you get to keep that money. That's very rare, because you know, it just gives you a chance basically for rich people to buy their way out of custody. A surety is where somebody says, I will basically pledge a sum of money for this person to turn up, and if they don't turn up, then you get to keep the money. That's what happened in the Assange case. So the idea is that the people, you know, you're meant to feel a moral obligation. You're usually quite successful. It's not necessarily the amount of money, it's how much it means to the person. So, you know, your grandmother putting up, you know, 200 quid when she's on a pension is probably going to get you further than your multi-millionaire friend offering to pay millions that he'd not even notice if it vanished. So, you know, that's one way. So when you sort of hear people say they've posted bail, we don't really have that here, because you don't actually have to put the money up front on a surety, you just have to promise to pay it. However, it is a strict liability thing. If you stand surety for somebody and they don't attend, you lose that money, and it doesn't matter. You can say, look, I argued with him, I pleaded with him, I physically tried to drag him there. It's like tough, because the whole point is it's meant to basically morally blackmail you into not letting your friends down. I mean, our US friends will know it's slightly different there, because you know, they post a bail amount, and then it's either you pay the full amount, but you pay 10% on a bond, and you can borrow that off a bond agency. And if you do abscond, the bond agency then chase you down, and that's where you got all your bounty hunters, you know, from. That's the bounty hunter idea. We don't really have that here. I mean, like I say, the courts are a bit sceptical about the commercialisation of bail, because you know, the argument is it's not just a revenue generating thing, and you shouldn't be, whether you're held in custody or not, shouldn't depend on how good your credit rating is with the bond agency. But there you go. As always, hope you found that vaguely useful, vaguely informative. Where am I today? I am at a place called Wheel Virgin. in the Poldice Valley, although now old Cornish will no doubt be saying it's Poldike or Poldice or something. But yeah, it's just another old tin mine. It's quite an interesting one because it was actually a worn out mine that somebody bought on the cheap, and then they found the largest load of copper in Cornwall underneath it. So they all got really, really rich. It was an amalgam of 6 different people who put money in, and the bank joined in, who'd lent the money to buy the place and to, you know, upgrade the boiler and stuff. That company did vanish in mysterious circumstances, and because it was doing so well, people are always trying to work out exactly what happened. Did anything go wrong? I mean, personally, I think they just took the money and scarpered. But there you go. As always, if you did, hello, more dogs. Hello, hounds. If you did, please consider subscribing to Dan, you know, Black Belt Barrister, because he's well on his way to millions of subscribers. And, you know, as I've said, personally, I do love it when you subscribe, but you don't have to. I just enjoy making these videos for you. There's another nice engine shed, engine house, wheel shed, whatever you want to call them, here that I thought, you know, you might like to see. So to try and justify this and make it still connected to the original video, if you commit an offence whilst on bail, by the way, that is an aggravating feature for the sentencing guidelines. So you always end up serving a little bit more, because the argument is, hey, we trusted you and you let us down. But yeah, I mean, to be honest, I can't really think of anything else. I suppose technically, while you're on bail, if you're remanded in custody, pending trial, you haven't been convicted. In the old days, that meant you had been sentenced to jail. You'd been sent to jail, sorry, because you hadn't been sentenced. But we don't really have the difference between jails and prisons anymore. Prisons were where you were sent off to actually serve your sentence. But now all the actual remand places are actually within the prisons themselves. So whilst all jails are now technically prisons, not all prisons are jails, because a lot of prisons don't actually. There we go, try and get the framing right on that. I'd have to walk backwards. Well, I'll just point it and have a look at it. I mean, you can always, you don't have to watch the rest of this video if you don't want, unless you're massively into engine sheds. This, by the way, is called Ale and Cakes Mine, sometimes called Cake and Ales Mine. Nobody seems to be quite sure as to what the original name was. This was actually a bit of a one-man band. Some like local lad just bought it, and again, it was another one that was effectively, supposedly, officially all mined out, but he managed to scrape some stuff out there. It is rather spectacular, and what I quite like about this one is you can go inside it. So if you actually want to see what they look like inside, that's basically where the big shaft would have gone out the front, and that's what's now that like pond, which is actually surprisingly empty considering how much rain we've had. It's usually really full, but that's actually the original mine shaft, which is why it's now a sinkhole. But there you go. So a little bit of Kernowek history for you. Hope you enjoyed that, and see you next time, unless of course I fall down this massive slope. I think I might just stop filming now.